Здравствуйте, уважаемые участники. Прежде чем мы начнем, мы должны проговорить с вами технические инструкции. Если у вас возникли какие-либо технические трудности с подключением или со звуком, пожалуйста, напишите об этом в чате. Если вы не говорите сами, не выступаете или не задаете вопрос, ваш микрофон должен быть отключен. Встреча ведется с переводом на 2 языка, синхронный перевод на английский и русский язык. Синхронный перевод идет по отдельным каналам. Для того, чтобы подключить синхронный перевод, пожалуйста, выберите один из этих 2 вариантов, даже если вы двуязычные. Кнопка подключения английского и русского каналов находится в нижней панели. Вы видите экран глобуса. Нажмите, пожалуйста, на эту кнопку и выберите язык, на котором вы хотите слушать. Когда вы будете задавать вопросы, пожалуйста, не переключайтесь с этого канала, оставайтесь на нем. Говорите четко, медленно и без перерывов. После презентации всех спикеров будет время на вопросы и ответы. Вы можете поднять руку, и вам будет дано слово, или написать свой вопрос в чат. И кто-то из команды передаст всю информацию из чата модераторам встречи. Мы также хотели бы напомнить, что в данной встрече любое уничижительное или оскорбительное выражение в чате или устной форме недопустимы. Такие участники будут удалены со встречи и внесены в черный список для будущих встреч. Спасибо.
Добрый день, доброе утро, добрый вечер всем участникам, всем спикерам. Спасибо большое за то, что сегодня присоединились к нашей встрече, к нашему вебинару. Фонд Батани сегодня открывает серию вебинаров, которые будут посвящены вопросам прав коренных народов. Наш первый вебинар будет посвящен опыту международных судебных механизмов защиты прав коренных народов. Будет состоять из 2 частей. Я, конечно же, хотел бы в первую очередь выразить огромную благодарность нашим сегодняшним спикерам и организации First Peoples Worldwide, которая любезно согласилась принять участие и предоставить нам, скажем так, уроки, которые будут посвящены этим вопросам. Тем более, что сегодня у наших спикеров бывает раннее утро, у них 7 утра, и они любезно согласились все-таки принять участие. Спасибо большое. В первой части нашего вебинара мы узнаем истории защиты прав коренных народов в Межамериканском суде по правам человека, знакомимся с тематическими исследованиями, демонстрирующими эффективные стратегии, а также с конкретными формулировками Межамериканского суда по правам человека и Межамериканской комиссии по правам человека. Наши коллеги касается ретроспективный обзор участия коренных народов в межамериканской системе, в которых были и успехи, и проблемы. Расскажут нам о том, как Межамериканский суд по правам человека, судебная система Организации американских государств, создала заметный прецедент, признающий коллективные права коренных народов. Во второй части вебинара мы прослушаем презентацию Яна Микаэла Лундмарка «Право коренных народов на традиционные средства существования в соответствии с Европейской конвенцией о правах человека и основных свободах как часть их культурных прав». Я хотел бы сказать, что мы ставим задачи и цели наших тренингов. И цель данного тренинга – это представить обзор дел, поступивших от Межамериканской комиссии по правам человека с целью создания у коренных народов возможности использовать эффективные правовые стратегии в рамках международных судебных систем. И сегодня у нас великолепные спикеры, профессионалы своего дела, преданные делу защиты прав коренных народов. Я очень коротко хотел бы представить. Кейт Финн. Кейт – исполнительный директор First Peoples Worldwide. Я думаю, что она является одним из, наверное, лидеров по вопросам, связанных с правами коренных народов от бизнеса. Кейт занимается вопросами, связанных как раз как влияет бизнес, как может повлиять бизнес на права коренных народов, и как необходимо эти права защищать. Кейт является автором нескольких статей в этой сфере и, в принципе, во многих и других. До того, как стать директором First People, Кейт работала штатным поверенным в компании First People. Кейт имеет докторскую степень и степень магистра государственного управления университета Колорадо, а также степень бакалавра искусств Принстонского университета. Кейт сама является представителем коренных народов. Кристина Стентон. Кристина является менеджером по глобальной политике и разработке стандартов First People. Она отвечает за интеграцию и продвижение прав коренных народов на международном уровне, включая разработку параллельной стратегии в рамках Организации американских государств. Она также работала помощником юриста в юридической компании в штате Колорадо, где занималась вопросами и работой с племенами, индейскими племенами по различным социальным вопросам. Она также имеет практику как в судах, иных судах, так и в судах штата. Кристина имеет степень доктора права с сертификатом права американских индейцев университета Колорадо и степень бакалавра искусств университета Джона Хопкинса. Микаэль Ян является докторантом юридического факультета в рамках программы Арктического университета Дарема в Великобритании. Он имеет степень магистра права университета Акурери, Исландия, степень магистра права Гетеборгского университета, степень магистра социальной антропологии также города Гетеборг. Ян в настоящее время исследует правовую защиту собственности или владения коренных народов, подпадающих под Европейскую конвенцию о правах человека и основных свободах. В настоящее время Ян Микаэль занимается анализом о том, как Европейский суд по правам человека применяет правовые принципы как раз в таких делах, связанных с защитой прав коренных народов. И цель его исследования заключается в том, чтобы ответить на вопрос, обеспечивает ли Европейская конвенция практическую и эффективную правовую основу для защиты земельных прав коренных народов с учетом их статуса. Так, сейчас я хотел бы слово предоставить нашим первым спикерам. Кейт и Кристина, пожалуйста, вам слово.
Thank you so much. I am going to quickly send out a link so that people can follow along with some of the cases that we're going to discuss, as well as some of the international instruments. And I will also be sharing my screen, so hold with me one moment. Wonderful. So our presentation from First Peoples Worldwide will be about Indigenous advocacy within the Inter-American system on human rights, focusing specifically on collective rights of Indigenous peoples. And I'll turn it over to Kate Finn to get us started.
Certainly. Well, thank you, Pavel. Thank you to the Batani Fund for having us here. We're honored to be able to present, and we thank you so much for the opportunity. And we'll go through this presentation rather quickly, and we invite questions at the end, and we invite a continued conversation about the ways that we can all work together to amplify the rights of Indigenous peoples. So I'll talk quickly here, and we'll move through about 70 years of case law in just a few minutes. Next slide. So the purpose of the webinar here today, as Pavel had said, is really to give an overview of the case law related to the collective rights of Indigenous peoples in the Inter-American system. So one of the key themes that we want to draw out today are the times when Indigenous peoples are not recognized in domestic law, but have reached to international forums in order to have their rights recognized and to have remedy and redress. So we are going to paint a clear picture, we hope, of when that's true, when Indigenous peoples are or are not recognized, and the best ways to reach to international law. And of course, we'll do that more specifically in regards to the Organization of American States and the Inter-American Commission and Court on Human Rights, because there is so much precedent there regarding not just individual rights, but collective rights generally, which I'll turn to Christina to give a brief overview of collective rights.
As many of us know, the concept of collective rights emerged because individual human rights do not guarantee adequate protection for Indigenous peoples and other minority groups exhibiting collective characteristics. And so I provided a list of some collective rights that we've seen. So the right to speak one's own native language and teach it, the right to cultural preservation, rights to lands and waters, and the right to determine what happens to those waters, a right to a healthy environment, right to self-government, and most broadly, self-determination as a collective right. Collective rights are very deeply tied to Indigenous peoples' spiritual, cultural, social, and economic connection to lands, territories, and resources. And you'll notice as we move through these cases that most of these collective rights issues are deeply rooted in property and land rights. Collective rights are articulated in the United Nations Declaration on the Rights of Indigenous Peoples, as well as ILO 169. But we also see it in regional human rights mechanisms like the American Declaration on the Rights of Indigenous Peoples. I provided some language on the collective rights enumerated in the American Declaration. And these include pretty much everything that I just listed, and requires that states promote, with full and effective participation of Indigenous peoples, the harmonious coexistence of the rights and systems of different population groups and cultures. It's important to note that, like the UNDRIP, the UN Declaration, a state's endorsement does not mean that they will implement the articles within their domestic legislature, but we do see the American Declaration cited often within the Inter-American human rights system. So I'll turn this back to Kate.
So before we dive even deeper into case law, I wanted to give an overview of the Organization of American States, just so to provide some understanding of how, why, and when Indigenous peoples can advocate for their collective rights within the system. So the OAS is the world's oldest regional organization bringing together all 35 American states, I think it's important to note that the OAS, among other mechanisms, was founded to protect fundamental rights of individuals. So I think it's notable that as we look at collective rights, to know that the development of collective rights is novel, especially in regards to Indigenous peoples. So while these cases have been ongoing for a number of years, the mechanisms have changed to adapt to a recognition of collective rights and not the other way around. So where you are advocating, it's important to note that the mechanisms sometimes are structured in different ways, but it has not kept Indigenous peoples from really advocating strongly for collective rights. So the conference began to meet in 1889, and then again, 1948, the charter of the OAS was signed. It's important to note too, and I'm sure we'll hear more about this later, that the OAS mirrors in a lot of ways the UN system. So the systems, when you learn to the mechanisms of one, they're very, very similar across at least the OAS and the UN. There are four pillars: democracy, human rights, security, and development. So again, just want to make the point with this chart, I know it's hard to see, that the UN and the OAS system are very, very similar. There's a General Assembly of which all of the states are a member. And then you'll see on the left side of your screen, the Inter-American Commission on Human Rights, which is more or less a political and diplomatic forum. And then the court, which is slightly different because it's a quasi-judicial mechanism. So those are the two aspects of the OAS that we will draw from today. And similar to the UN, the General Assembly is the supreme organ, which comprises delegation of member states, which can each vote. And we just wanted to make a note that the language in regards to international mechanisms can be jargon. It can be a little bit technical. And so the word organ is what's used to describe all of these different entities within the OAS. So the system itself that we just showed you has a series of mechanisms, a series of different ways to protect human rights. And the Court on Human Rights and the Commission are only two. So there's political routes and there's quasi-judicial routes, and they have different interactions with the states. Similar to the UN system, there's other specialized instruments that deal with different kinds of topics that can be leveraged and used as well. The OAS, similar to the UN, interacts with member states politically. So they can visit states, they can prepare reports about human rights violations, they can elevate issues to political actors, but it's also functions quasi-judicially and judicially in that it can receive petitions, it can elevate human rights violations, it can examine cases and then adjudicate them, and of course, create case law.
So I will talk a little bit more specifically about the Commission and the Court. So the Commission was installed in 1979. It is an autonomous organ of the OAS, and its mission is to promote and protect human rights in the American hemisphere. Headquartered in Washington, D.C., and it operates with three pillars. The first is individual petitions. So individuals or organizations can submit petitions to the Commission. In order to do so, they must have exhausted the domestic remedies in their own country. And as we'll sort of touch on throughout this presentation, often the exhaustion may not look like it looks domestically. So exhaustion could include when someone has filed a case and it has moved slowly through the system, you can still go ahead and file within the Commission. Or if there are not judicial mechanisms to protect the Indigenous peoples in the state, then you can go ahead and file it in the Commission. You can file a petition to allege violations of human rights through action, omission, or acquiescence of the nation state. There's also monitoring of human rights situations in member states that the Commission provides. So this is often after a petition has been elevated to their attention, or perhaps through some other mechanism like a special rapporteur. They devote attention to thematic areas and provide reports. And the Commission will determine if a case brought before it is admissible, inadmissible. They might facilitate friendly settlement, which is a voluntary settlement between the petitioners and the nation state. They may issue a decision on the merits, or they can send the case to the Inter-American Court on Human Rights. A final thing to note about the Commission is that in issues of extreme urgency and harm to a person or persons, someone can file a petition for, a request for precautionary measures in order to elevate something more quickly through this system. The Inter-American Court, on the other hand, is located in Costa Rica, and it has three functions. One is to resolve contentious cases and supervise judgments. So in matters where the Commission has forwarded a case to the court, they will look at that case. So this could be if there was no ability to reconcile the issues within the Commission, or if the Commission issued recommendations and the member state did not follow those. They also have an advisory function where they can suggest to member states how to interpret certain international documents or even their own cases. And lastly, they have the power to issue provisional measures. It's composed of 7 judges who are nationals of OAS states. They are elected and they must recuse themselves if a case before the court involves their own nation. 20 states are members of the court, so they have submitted to the jurisdiction of the court. And this is notable because the court must have jurisdiction to hear a case. So sometimes you will see cases brought before the Commission that cannot then be elevated to the court itself because the nation state in which it was submitted does not submit to that jurisdiction. So we see that a lot with the United States. Only state parties in the Commission can bring a case before the court. And finally, one last note, cases move through this for about 2 years. So this is a long process if a case is elevated to the court. Some of the guiding documents that we're going to be referring to, I've listed here. These are Inter-American declarations and conventions that guide a lot of the human rights violations that are alleged within these systems. The American Declaration on the Rights and Duties of Man was adopted in 1948 and was the first general international human rights instrument. 8 months after this was passed, the UN adopted the Universal Declaration on Human Rights. There's a very brief mention of Indigenous peoples here in the section on rural labor, but for many of the cases that we'll discuss, this was one of the primary declarations that was relied on for case law. In 1968, the American Convention on Human Rights was adopted, and this articulates many of the human rights that are also heavily relied on with the case law and precedent in this system. In 1972, the Inter-American Commission issued a special protection for Indigenous peoples where they noted that member states especially need to protect the Indigenous populations. They called it a sacred commitment. And this is notable because it really started to shift the way that the Inter-American human rights system responded and elevated Indigenous people's rights. In the 1980s, we were starting to see the broader international discussion about Indigenous rights. And after the UN Declaration on the Rights of Indigenous Peoples was passed, we had the American Declaration on the Rights of Indigenous Peoples passed in 2016. And this is very similar to the UNDRIP, except it does have a few extra sections. So there's discussion about voluntary isolation of Indigenous peoples affected by armed conflict. And there's also a strengthening of provisions regarding treaty rights between member states and Indigenous peoples. I wanted to include this graphic, which again, may be coming up a little smaller on your screen, just to show the sheer amount of petitions that are submitted to the Inter-American Court. You can see we're in the thousands in the most recent years, but as you go down and notice how many have been determined admissible, how many merits reports have been issued, the numbers are much smaller. So similar to the legal system in the United States, the amount of cases submitted to our highest court versus the amount of cases actually heard by the court, there's a huge discrepancy in those numbers. So I'm now going to move into our very broad discussion about the early cases in the system and where we are today. So as I mentioned, Indigenous peoples will bring cases before the Inter-American Commission, and then these cases will move to the court if there's no resolution or implementation of the recommendations. So this is a very long process, which often started many years prior to submitting a petition in the member state itself. Again, the commission will issue non-binding recommendations, but if the case makes its way to the court, those recommendations will become binding. And that is rooted in the American Convention on Human Rights, Article 68. So we started to see some notable Indigenous cases in the 1970s and 80s. The first one was with the Guahibo people in Colombia in 1972. In Colombia, there are treaties with Indigenous peoples which guide the domestic relationship. And this is notable because this is the Commission's first reference to the duty of the state to defend Indigenous lands. At this time, the state had been creating incursions on ancestral lands of the Guahibo people. The Commission articulated that Colombia had a duty to honor the treaties that had been signed and to defend Indigenous lands. I will also be providing some context as to where those relationships are now. And that provides an important distinction because, as we all know, the determination of a court or commission may not have the same on-the-ground results. And so unfortunately, here in Colombia, there are still significant human rights violations. However, the Constitution itself was revised in Colombia, which guarantees more human rights to Indigenous peoples than any other Latin American country. And I believe Indigenous peoples in Colombia now own more than 30% of the national territory. Another important case from early on is in 1982 in Nicaragua with the Mosquitos people. Similar situation where there are many treaties with Indigenous peoples. There's also the Episcopal Conference of Nicaragua, which states that there is a right and duty to protect the legitimate possession of Indigenous land. Here, there was significant forcible resettlement of the Indigenous peoples, and there were allegations of violations of the right to life, to personal liberty, to personal security, to residence and movement, and of course to property. And all of these allegations were brought under the American Convention on Human Rights. The Commission looked to that convention, as well as other international instruments like the ICCPR, for language to articulate the rights of minorities, because at this point, there was not specific language about the rights of Indigenous peoples, so there was heavy reliance on the rights of minority and ethnic groups. The Commission found that international law did not allow the view that the ethnic groups had a right to political autonomy, but they did recognize that there was special protection required for the use of their language, the observance of religion, and in general, all other aspects related to cultural identity. They said that if Indigenous peoples were not permitted to observe their cultural values, it would lead to forced assimilation with results that could be disastrous. And so this is another theme that we'll notice throughout. A lot of these collective rights are based on this right to culture and the ability to carry out one's own culture. In both of these cases, we're looking at the treaties between the domestic state and the Indigenous peoples. The cases were brought based on that treaty language alongside language in the American Convention on Human Rights. And the court looked to both of those things as well as other international law, such as the ICCPR. In 1985, the Yanomami Indians of Brazil brought a case in front of the Inter-American Commission. And this is notable because it was the first instance of an intergovernmental organization issuing a resolution of land demarcation to protect the collective cultural identity of Indigenous peoples. So again, we see that cultural identity coming up as a way to protect collective rights. And ultimately, in this case, it secured their land rights. And so land demarcation is something that we'll see in many resolutions from the Commission and the court as a way to help Indigenous peoples secure their land. So this case was filed in 1980 and was not resolved until 1985. The Brazilian Constitution guarantees indigenous peoples rights to their own territory, as well as exclusive natural resources use. So something that is different with all of these is the way in which the constitution of these member states recognize indigenous peoples. And so here we have a pretty solid recognition of territory and resource use. However, Brazil was attempting to exploit natural resources like mineral deposits, and so essentially began this process of demarcating boundaries of a national park that would create something like a reservation for the Yanomami Indians. The Yanomami Indians filed in the commission saying that all of these efforts brought by Brazil to protect their rights were ineffective. And they alleged numerous violations of the American Declaration on the Rights and Duties of Man. The commission recognized collective rights for a variety of rights articulated here. So the right to life, liberty, and personal security, the right to residence and movement, the right to preservation and health. And they require that Brazil take steps to implement these. So for the most notable, as I mentioned, is the land demarcation. And in doing this, they cited to the American Declaration on the Rights of Man and the ICCPR Article 27 on the right of ethnic groups to preserve cultural identity. A few years later, in the 90s, individual and collective rights of indigenous peoples were explicitly recognized by the state in the enactment of their new constitution. Moving into the 90s, we have the first of a series of cases involving Suriname. This is Aloha Batohi v. Suriname from 1993, which recognized the lawfulness of reparations based on indigenous family customary law. So we're introducing sort of a new series of collective rights here. And this analysis is notable because it merges international standards, indigenous customary standards, so indigenous law, and domestic law. In Suriname, there is no recognition of indigenous people's rights, which is probably why we have so many cases involving Suriname go through the Inter-American human rights system. In the 80s, there were a series of violent attacks against the Aloha Batohi people that were perpetuated by the state of Suriname. Suriname ultimately conceded that they were responsible for these, so this case moved through the commission and then into the court when Suriname agreed that this had happened. The commission had stated that Suriname violated several rights, including the right to life, and required that Suriname pay reparations to the next of kin. And this is where we see this analysis of these different kinds of law. So in Suriname, marriages must be recognized through the state. However, the Aloha Batohi people practiced polygamy and did not register any marriages with the state. The commission said this should not affect the right of compensation of the relatives or spouses of unregistered marriages. So they recognized the indigenous customary practice and did not think that should affect how they determined the reparations here. Then they looked to broader international law, looking at the ILO 169, looking at statutes from the International Court of Justice to determine specifically how they should calculate reparations in this situation. So we'll continue to discuss Suriname as we move through this, and I'll provide more updates about that current relationship. In the late 90s, the Rio Chito in Paraguay brought a case before the commission, which was the first friendly settlement to restore property rights to an indigenous peoples, based on Paraguay's failure to adhere to its own law. So again, this is a voluntary settlement between the Rio Chito peoples and the state of Paraguay. The Paraguayan Constitution does recognize the rights of indigenous peoples and communities to own land. And so when the government began selling the land all the way back in the 1800s, the Rio Chito people began pursuing their own remedies in domestic court. And the court itself in Paraguay granted injunctions to them, trying to stop various changes to the land, but landowners and Paraguay did not listen. And so because they were not able to actually get any redress within their own country, they filed within the commission. They alleged violations of the rights to judicial protection, fair trial, property, residence, and the benefits of culture. So again, we see that combination of culture and property. The commission sat down with all these parties over a number of years and months and essentially created a resolution where the state of Paraguay would acquire back a significant amount of land and then deed it over to the Riachito peoples so that they could recover their ancestral lands. They were also required to provide food, sanitary, and educational assistance to protect other collective rights that they had alleged violations of. So very shortly after this, the land was deeded back to the indigenous peoples' communities. However, there were no major progress related to food, sanitation, and educational assistance. So we did see some success for part of this, and then for part of this, the state failed to provide and follow the friendly settlement resolution. Awastingi v. Nicaragua in 2001 is one of the most notable cases that has moved through this system, and it has involved the commission and the court recognizing indigenous collective rights to traditional ancestral territories, as well as the requirement for consultative participation about decisions regarding those lands pursuant to domestic law. We'll see references to the right to culture, and this marked this transition of understanding of indigenous land claims to indigenous land rights. Again, this is a case that took a very long time to move through the system, being filed back in 1995 and finally reaching some sort of resolution in 2001. So the Nicaraguan Constitution does recognize the existence of indigenous peoples as well as communal forms of property. Here, a private company had been granted the rights to log on in a forest, which was possessed by the Awastingi people. There was no consultation, and the Awastingi directly opposed any logging and construction that was occurring in these lands. They filed various cases domestically, and ultimately the Nicaraguan Supreme Court did rule in their favor. However, Nicaragua failed to adhere to that ruling. And so they were faced with the decision to file before the commission so that they could seek some form of redress. After they had filed with the commission several times, that was referred to the court following Nicaragua's non-compliance with their recommendations. So the commission had stated that Nicaragua did violate the American Convention on Human Rights, and they said that continued utilization of traditional collective systems for the control and use of territory are essential to the indigenous people's survival, as well as their rights to individual and collective well-being. And so now we're seeing this understanding that the rights to access one's ancestral territory is not simply about the ability to practice culture, but it's about one's collective right to be well. The Awastingi community has property rights to lands and natural resources based on a pattern of use and ancestral traditional occupation. And they said that entitled them to protections under Article 21 of the American Convention. The court concluded the same, that Nicaragua had violated rights to judicial protection and property, and ordered the government to demarcate the land. They relied on the right to property as defined in various international instruments, all of the ones that I had just listed, as well as Article 27 of the ICCPR. The court also focused a lot on the fact that here the Awastingi had attempted to go through the domestic system, but their rights to judicial access were not properly protected. And so this is an example of the ways in which the domestic system has failed the indigenous people, and they were able to seek redress internationally. Ultimately, there were laws passed to demarcate the indigenous land, and it was awarded back to the Awastingi. So I'll try to move through these last few a bit quicker. The Saramacca peoples versus Suriname. Again, we're back in Suriname, where indigenous peoples do not have protection under the Constitution. This is the first international tribunal that's cited to the UN Declaration on the Rights of Indigenous Peoples, namely Article 32 on the right to lands, free, prior, and informed consent, and effective measures of redress. The court emphasized that control of indigenous property was necessary, as well as the ability to control their own resources, and that these were aspects of collective self-determination. The court concluded that members of the Saramacca people made up a tribal community, and tribal communities are protected by international human rights law that secure the right to communal territory. So again, we're seeing this reiteration that ancestral lands should be protected and that Indigenous peoples have the right to control what happens to those lands. The judgment of the court required Suriname to change its laws and, if necessary, the constitution so that the rights of the Saramacca people would be protected. However, we still see today that Suriname is motivated by modernization and national development and has continued to postpone the court's judgment protecting the rights of Saramacca peoples. Here's just a brief quote, again, that articulates the ways in which the demand for collective ownership derives from the need to control and use natural resources and maintain their own way of life. In 2016, the Karinya and Lakono peoples, again, we're in Suriname, brought a case because there were two companies mining on their lands. There had been no consultation and no consent given here. And the court asked Suriname to implement a series of guarantees of non-repetition, requiring that Suriname finally legally recognize the territories of the Indigenous peoples. So this is because we've seen this series of cases brought through, and the court is able to not only rule on the individual issue, but also rule on the normative framework of laws within the domestic system. And so they're recognizing that these series of cases have been brought because there is no protection of ancestral title in the land. This is a notable case because at this point, we're starting to integrate environmental rights and Indigenous rights. And the court described Indigenous and environmental rights as complementary rather than exclusionary, and that we can look at these together. And so this case also refers to the UN Declaration, but also the Convention on Biological Diversity and the UN Guiding Principles on Business and Human Rights. So we're starting to see the integration of other international documents and guidance for the court as they make their decisions. So not specific necessarily to the OAS system, but within the international field more broadly. And finally, we end with the most recent case that was brought last year with the Lackawanna Association against the state of Argentina. And this is the first environmental rights case to be heard by the court. They analyzed rights to a healthy environment, Indigenous community property, cultural identity, food and water, all under Article 26 of the American Convention. It recognized that there was a duty to prevent as an affirmative action of the member state. Non-compliance is not necessarily proved by a rights violation. It also acknowledged that rights violations occur with greater intensity for Indigenous peoples. And so the thing here is that we're now looking at environmental law a little bit differently as it affects Indigenous peoples. So previously, the inter-American institutions were dealing with environmental issues by discussing environmental degradation in the framework of human rights violations. But here the court is saying harm to the environment is a justiciable independent right. You don't even need evidence of harm to individuals. And so since this was just resolved last year, we don't know where this is going to take us, but it is an interesting case to point out. And so with all of that information I've just thrown at you, I did want to draw out a few themes that we've seen throughout this case law as it's moved through the commission and through the court. So Kate, I'll have you talk about the corporate advocacy tool first.
Absolutely. So as Christina had noted, as time increased, different international mechanisms, different international instruments have been referenced and included in case law in the inter-American system, which shows that Indigenous peoples all over the world have activated a number of different strategies to protect their rights, especially when the domestic regime does not protect their rights. So I just wanted to say that it's important in many ways to activate different kinds of strategies. Our work here at First Peoples is to work with corporations and financial institutions to urge them to respect the rights of Indigenous peoples under the guiding principles. And when there are favorable rulings through international mechanisms or reports or statements, those are important tools of advocacy in and of themselves. So while they may not always reach the ground in implementation, what we can do is use those reports and use those findings to talk to corporations and to implore them to fulfill their obligations, both their fiduciary obligations to their shareholders and to their own commitments, but also to the UNGPs. So as Christina noted, sometimes the case law and the rulings don't always change what's going on the ground right away. There are other ways to use these rulings and these reports that help to protect and help to preserve rights and land for the future.
So a few trends that we've been noticing is that in the last decade, there's been increasing integration of other international guidance within the OAS system on human rights. And so it's not OAS specific, but we've seen the integration of the UNGPs, as I just mentioned, the Convention on Biodiversity. I imagine we'll see more of that. And so this has been used alongside the domestic law, alongside the tribal customary law for the court to make its rulings. Again, I mentioned that there's often always parallel domestic litigation if that's available for Indigenous peoples. Often this is not exhausted, but it is extensive. And so when we do see these favorable cases for the collective rights of Indigenous peoples, it is the result of decades-long efforts domestically and internationally. So I mentioned a lot of cases where there is domestic recognition of collective rights or property rights of Indigenous peoples in Latin America specifically, which is very unique. But what we've noticed in all of these is that often these are not actually enforced. And so the court has taken it upon itself recommendations for the nation state to enforce its own constitution or its own laws in order to protect Indigenous land rights. We also see a lot of parallel international advocacy. So there's been engagement with rapporteurs, both within the UN and the OAS system. There's been filings with treaty bodies like the Committee to End Racial Discrimination. And whenever these are also brought alongside any OAS advocacy, this is referenced by the Commission and court. So they take notice when there's been advocacy within CERD or when there's been advocacy within the Human Rights Council. They'll cite statements, as Kate said. So anything else that is going alongside the advocacy within the OAS system is generally taken into account, though obviously we do recommend that anyone that's engaging in the system make sure the Commission and court are aware of that. So continuing to update filings as they move through these systems slowly. I mentioned that favorable rulings or recommendations are not necessarily indicative of what's happening on the ground. But as Kate mentioned, these can still be tools for advocacy in other forums. A few of these cases are notable because they were brought by an entire peoples instead of a few clans of a specific Indigenous group. And that is something that's always noted by the Commission or court and might play a factor in how they look at the engagement of the Indigenous peoples with the nation state and the domestic system. And finally, I mentioned that the court has the capacity to make rulings that respond to systemic problems that have created the individual claims. So when they are seeing that there is repeated violations by the state of collective rights to ancestral territories, the court is issuing recommendations that this be addressed at the root of the issue. Instead of a specific issue, let's look at how do we change the Constitution. And so those are a number of things that we've noticed and observed throughout. That was a ton of case law to throw at you. I hope that I've attached a few judgments that you can take a look at the language of specifically, since we didn't get into all of that language. But with that, we will conclude our presentation and move into the European Court, I believe.
Спасибо большое, Кейт, спасибо, Кристина, вам за прекрасный доклад. Да, сейчас мы послушаем Ян Микаэла, а потом перейдем к вопросам, которые наших участников. Спасибо большое. Ян Микаэл, пожалуйста, вам слово.
Okay, thank you. See. Okay, so I will try to make this interesting, because going from one system where you have a lot of case law, going to another system where you have a totally lack of case law linked to indigenous peoples, many people ask the question, can you use the European Court at all for indigenous people's cases? There are only one case who has survived the admissibility stage, and that case is not about property, it's about the right to a fair trial. So there was a question in the chat, I had Googled it, but so this is the jurisdiction of the court. So Russia is covered by the court. So if you're in Russia, you could take a case to the European Court if you'd like to. My presentation focus on the right to property, and the article in focus is the first article in the first protocol, which I call the right to peaceful enjoyment. Unlike the South American system, the European Convention does not have a right to property. You need to have a property to begin with to argue your case. And Article 8, which is the right to respect for private and family life. And like the South American system, there is a shift towards Article 8, which covers cultural protection. I would not say that there is a cultural right under the European system, but we see that cultural dimensions of other rights is beginning to become incorporated, including the right to an identity. That said, I just want to mention that when you have the right to peaceful enjoyment, I will come back to this, how this is defined depends on the fact of the case. So there are case law indicating that the court can interpret this depending on other articles or other issues that the applicants have. For example, I will provide you with one example where the applicants have a certain conscience how his land is going to be used. And the court took that into account and broadened the scope of what the right to peaceful enjoyment actually means. But making a general assumption or trying to explain in general what how you should apply to the European Court, it's kind of difficult. But I will try to provide you with key points about how you can apply the property rights article in connection to Article 8. So one of the basic ways of thinking about the European Convention is when you speak about property rights, it's all about access to land. So you have these pre-state rights, so to speak. The indigenous people existed there prior to the state, and then you have this national state coming, claiming sovereignty over the area. And by giving others access to indigenous land, you basically restrict indigenous people's access, which can violate your right to peaceful enjoyment of your property. Because if you, for example, give a company access to build a pipeline, the indigenous people's access to that land which they have used will be restricted in one way or another. And the same goes if you give up fishing rights to a company, then indigenous people's right to access that specific resource can be restricted in some way. So it's how you view your rights. If you have a right to a certain way of life, or if you have a right to access your ancestral land. To explain the right to peaceful enjoyment, so it's a general article. It consists of three different sentences, and the first sentence expresses the right to peaceful enjoyment, and it's really a general expression. It doesn't say anything. What it says is that you need a possession to begin with, and it cannot be extinguished. So you can't use it as a way to argue for land that you have legally lost, for example. And the court is really reluctant to give remedies to those who have lost their properties. We saw that when Eastern European gained access to the court. So the right is expressed in the third sentence, and the other two sentences provides the basis for the state to interfere in this right. And this is important to keep in mind, because what kind of coverage the first sentence or the first right gives you depends on which jurisdiction the state has to interfere with your right. And that can only be interpreted depending on if there are other articles involved in the case. So if there are other articles, the basis for justifying an interference could be limited, especially when you have, for example, Article 8. The way it works is that you have a right to peaceful enjoyment, which says nothing, and then you can have other articles which defines what it means. For example, and I will provide you with an example, Article 11, the freedom of assembly and association. This can actually broaden the scope of your right to peaceful enjoyment, and thereby reducing the state's right to interference with your right. And this is because everything is connected. So the second and the third sentence provides the states with some basis for they can interfere, because when it comes to the convention, you have to realize that although it provides us with rights, it actually is about limiting the state's right to interfere with them. And of course, this is for historical reasons. Let's see if we can. Okay, so we have this case, Chasson and others versus France. This is an interesting case. So basically, the case is about French landowners who owned a piece of land, and they didn't like hunting for ethical reasons. They thought that hunting was wrong. So they went to the court and they argued protection of property, and said that for ethical reasons, we don't want hunting on our land. The thing was that they were obligated to give their hunting rights to hunting associations. So they were forced to have hunting on their land. So they argued Article 9, which is the right to freedom of conscience, for example, and the freedom of associations, because they didn't want to be a member of this hunting association, and they thought that hunting was wrong. And the case is interesting, not because the court decided it on the basis of the conscience that it was right, that it was wrong for the state to allow hunting on the land, but they decided the case against Article 11, which was it was wrong to force them to be a member of this association. So it was a freedom of association. What is interesting is the court's argument, which is kind of cryptic if you read the case. But what is court says actually is that that freedom of conscience is a right or freedom protected under the convention was a relevant factor. So it was incompatible with the convention to control the possession of the landowners for the benefit of others to carry out an activity contrary to the concessions. And this is a disrespect of their fundamental rights, and to control them in a way that is totally opposite to their ethical belief. And this kind of holistic approach to convention is kind of unique, because sometimes the convention actually, or the court actually says that they say something but they don't say it, and that's why it's so hard to read the case law. But what it represents, this case, is that you cannot just simply consider one article without considering other articles in the convention, because if you apply one article in a certain way, the other articles or the other protection of the convention will be incompatible, not incompatible, they will be worthless, so to speak. So this law is important because it shows that if you want to use the convention, you have to consider how the rights are connected. And I think that most cases, indigenous cases which I have read, focus very much on the right, but less on the state's basis for justifying it, or and why this should be limited. Because I think that Shazam represents this is a very interesting way that it actually is about regulating the state's right to interference with the. So if you compare to the South American system, where culture is important, we also see that Article 8, which covers cultural dimension of human rights, becomes more and more important. And there are case law concerning minority rights, where Article 8 gains importance, and especially the way of life, which is usually used in minority cases. And the scope of Article 8 differs a little bit from the rest of the conventions, because the articles, because it covers our private sphere. So it covers the right of respect, which is, it's only one other article in the convention that actually speaks about respect. So when the state does things, or they have to respect our private sphere, and that is linked to the right to autonomy and the right to dignity. So Article 8 contains a lot of obligations for the state to either interfere in the protection or to refrain from interfering or refrain from taking measures. So the state in some way has to determine whether their way of dealing with, for example, land right of indigenous peoples violates their respect for their tradition and their way of life, which of course is problematic if you have a colonial state who's going to decide if their way they are dealing with indigenous peoples is respecting their rights. But I don't think we should underestimate that Article 8. Some people do, just because there was one case in '83, a Sami case, which is on indigenous peoples in the north of Scandinavia and in the Kola Peninsula in Russia, where they argued Article 9, but they were unsuccessful. Now, this was over 30 years ago, and a lot of things has happened. But what the court says in that case is actually that the way a state does something can be in disrespect of specific lifestyles. And this applies also to property rights cases, because this case was basically about the property rights of the Sami. And the court has later developed this, meaning that in order not to show disrespect, you have to take positive actions sometimes, especially for minorities and those in vulnerable positions. What is interesting in Article 8 is that there are also other case law saying that in connection to the respect which is supposed to uphold, sometimes you have to consider protecting property rights, although property rights normally should be examined under the first protocol. You have to consider them sometimes when you consider the respect that a person are entitled to as a way of as a part of their individual rights. Otherwise, you risk the measures risk amounting to a discrimination in violation of Article 14. I can just mention Article 14. So Article 14 has no self-standing in the convention. You have to connect this to another article. And how it is going to apply in indigenous people's cases, we really don't know, because there's a lack of case law also in relation to this. I can just mention, because we mentioned customary rights, one interesting aspect of Article 14 in relation to property is that indigenous peoples has customary rights to the land, and how should the state handle this customary right? Because if they don't take positive actions, they can risk discriminating indigenous peoples, because I mean, there are cases saying that you need to take positive actions, otherwise you will discriminate them. Article 14 is interesting because the obligation to take positive actions against minorities, there is actually one case. So this case is not an indigenous case per se. It's about a landowner who had hunting rights on his land also. But also the Sami village, who has the right to use the land, had hunting rights as part of their customary rights. And so the state restricted the landowner's access to land, or the landowner's right to hunt, for the benefit of the Sami. And in this case, the court or the commission actually indicates that there can be a positive obligation to take positive measures to protect indigenous peoples, because this is in the general public to do so. So this was the commission. The commission was abolished, it doesn't exist, and it was a little more proactive than the court is. So it's hard to draw too much conclusion. But there are cases later that says that you need to take positive actions to protect indigenous peoples. So what this means to take positive actions, well, we actually don't know, and it's cultural, and there are a lot of different indigenous peoples in Russia, and they all have different culture way of living, and also they attached different cultural values to certain activities, for example, hunting and fishing, or reindeer herding. But what the court says is that there is an obligation to respect the lifestyle of minorities, and this includes the respect to control the formation of the lifestyle, including the freedom of identity. And this, of course, doesn't come from indigenous people's case law. It comes from other people's case law, from ordinary peoples, where the court shows that if there are fundamental elements of your lifestyle the court or the state needs to consider this when they are going to protect your lifestyle. Otherwise, there is a risk of violating your human dignity because it reduces your autonomy, for example. And I can just mention, because the European Convention doesn't contain any group rights for historical reasons, and it's very hard to argue group rights for the court. But there are ways of doing so by connecting it to human dignity. Because the court says only in exceptional cases will they consider group rights. Well, they couldn't consider group rights if you can name every members of the group. I can also say, when it comes to the European Convention, what happens on the national level is very important. The European Convention has a limited jurisdiction to go in and tell nations that their laws are wrong. And usually they will say what the problems are, and then you have to fix them somehow. But what is clear from the case law is that the connection between different articles is the most important for indigenous peoples. If you're going to protect your property, there was one Swedish case, luckily they won in Sweden, but they didn't argue Article 8 in the Swedish court, which is something you need to do if you want to argue it on the European level. But what the case law shows is that you need to connect different articles to each other in a way that they need to be considered simultaneously, and that could be a problem in itself, which sometimes the court is reluctant to actually consider different articles in the same way. Sometimes they do. But it is clear that when you have different articles, the court do consider them, even if they sometimes doesn't say it. Especially in the Chanson case, where they considered Article 9, they didn't say it, but from the wordings of the case, it's clear that they did. So sometimes I always say that most people argue we should change the court's view on indigenous peoples. I usually argue we should reshape our thoughts of the convention and how we should use it. Because we should look at the convention and use the convention case law, because there is a reluctance in the European Court to use international agreements. They do refer to them, but claiming that you have rights under international law will seldom be a valuable way to go in the European Court if you can't argue your case out of the case law of the court. So it's see if we can say something more. So is it possible to use the court? And my analysis is that yes, it is. You just have to read a lot of case law. You have to connect different cases, which is not only indigenous people's cases, because you need to show the courts that, well, you did protect this group's relationship to the land for this reason. There's a French case, a group of travelers who lived on a piece of land. This was connection to home, and that the protection of home is much stronger than protection of way of life. But they also look at the relationship with the land itself. So connecting the indigenous people's right to our relationship to land, which exists under international law. Through the case law, you can actually make a good argument that we have the relationship to land, which we need protection for, and this is the case law that you use in other cases, where you're going to protect our ways of life. So you can protect the cultural diversity, which is one of the main functions of the European Convention, for example. This is a lot of theoretical discussions, but that is the problem with the European Convention to apply it. There are, of course, other articles. One article that what is valuable is Article 6, which is the right to a fair trial, because you have a right to have everything considered, because everything is connected. So you have all these different rights, where you have the right to culture, you have the right to a way of life, you have the right to identity, and you have the right to peaceful enjoyment of possession. You just need to link those rights to each other. And then, of course, to connect them to why should the state protect us differently from others, on which grounds. Article 6 is important because you have the right to an overall assessment in all the cases, which means that the court has to consider everything, including your customary rights. And they also have to give you an example, clear example of why you didn't lose or why you did lost, which is the most cases. I think I should stop there and ask questions, because then I can give you more answers to what you really want to know about the European Court. Thank you.
Спасибо большое, Ян Микаэл, за вашу интересную презентацию, интересный рассказ. Сейчас мы перейдем к вопросам. Итак, я просто хотел спросить у Кейт, у Кристины, вот те вопросы, которые мы вам пересылали. Есть ли у вас, готовы ли вы, или мы послушаем какие-то новые вопросы, если есть у кого-то? Пожалуйста, кто хочет задать вопрос, вот есть внизу экрана raise hand, да, то есть вы можете поднять руку, и мы дадим вам слово, чтобы вы задали вопрос. Я обращаюсь к участникам. Если пока еще нет вопросов, я хотел бы задать вопрос, озвучить точнее вопрос, который уже был задан в чате, наверное, ко всем, Кристине, Кейт и Ян Микаэлу. Один из участников задает вопрос: если в Российской Федерации на самом деле нет, да, практически у коренных народов права собственности на землю, есть возможность получить свою собственную землю в аренду, оформить и так далее. И вот здесь говорится в вопросе о том, что у наших общин, некоторых, не у всех, к сожалению, есть официально заключенные договора аренды на свои земли, свои охотничьи и рыболовные угодья. Является ли это как бы вот той ситуации, когда мы не являемся собственниками земли, но в то же время мы контролируем ее, живем на ней, ведем традиционную деятельность, и будет ли являться это формальным поводом отклонения заявления в суд?
I will go ahead and answer that from the position of the OAS system. And I wrote this in the chat, but if an indigenous peoples were to hold a lease to a land, I would first say, what are the rights under that lease domestically? And could you bring any case within the domestic court? And of course, that's, you know, dependent on the laws of the state and judicial access for the indigenous peoples. In the OAS human rights system, what we've seen from the commission and the court is that they look to not only legal title which some indigenous peoples have, some do not. But what does that relationship to the land look like now? Are they using the land? Are they managing the land? Are there ancestral ties to the land? And so it's a very holistic approach to see the relationship between the indigenous peoples and the land, whether or not there is legal title. And so that is how that would be addressed in this system particularly. But of course, you know, that's specific to the OAS.
I'll just add a quick gloss to that. I think what we learn in the OAS system is exactly what Jean-Michel is pointing to, which is that the strategy is to look at all of the rights that are connected in this particular issue and to think strategically about how language from different parts of the world can be used to articulate a particular land management or use or economic development scheme of land, and then to look at how indigenous peoples have been able to engage in all of those different ways as connected to the land as well. So there's a number of different ways and different rights that can add up to a claim, particularly in the OAS system. And Christina has really pointed out the ways that strategy to connect all of the rights is really starting to catch on now and become a very viable strategy moving forward.
Okay, so a contract would be a possession under the European Convention. The extent of this possession or the scope of it depends on the case. I mean, on the facts of the case. But it would, if you have a contract or a lease, that would be a possession, and that's protected under the convention per se.
Спасибо большое. Есть ли еще у кого-то вопросы? Я пока не вижу вопросов. Да, вот здесь вопрос. Ян подробно рассказывал про статьи Европейской конвенции. Как правильно называется этот документ? Точный документ.
It's the European Convention of Human Rights and Fundamental Freedoms. That's is the name of the convention. And then you have the property rights, which is in the first protocol. It's actually named property rights. So that is a right of property. You need to have a property, otherwise you can't argue that. That said, there are circumstances where you could go to the court and says that you think you have a property, and it doesn't. I mean, if the Russian state doesn't accept that you have a property, it in reality it doesn't mean so much if because the court can consider that you have a property anyway. So I mentioned Article 6, the right of fair trial, which is important to argue on the domestic level. And then you have Article 8, which is the respect for private and family life. So Article 8, it covers much more than it says. So it covers protection of ways of life. It covers cultural dimensions. It covers identity. And you could make an argument for possession of land as a group. It's harder, but you can make that under Article 8 as well. Thank you.
Ян, Михаил, вопрос к вам дальше следующий. Россия ратифицировала эту конвенцию?
Yes, Russia has ratified the convention, and also the time to submit an application to the convention, which is reduced from August, it's only 4 months. You need to keep that in mind because now it's 6 months. But yes, they have.
Спасибо большое. У нас Андрей Данилов хотел задать вопрос. Андрей, вы слышите?
Да, слышу.
Пожалуйста.
Спасибо за возможность задать вопрос и за упоминание народа сами как лучшую практику в судебном производстве. Но у меня возник вот такой вопрос. Сами является транснациональным народом, и отстаивание прав, может ли отстаивание прав сами подавать коллективный иск, как сами 4 стран или нескольких стран, затрагивающих интересы сами, как одного народа? К примеру, компания «Норильский никель» имеет свои производства как в Финляндии, так и в России, и наносит вред и не сотрудничает с коренными народами должным образом. Может ли народ сами подать вот такой коллективный иск к Норильскому никелю и государствам о нарушении прав сами на владение землей, на здоровый образ жизни, на окружающую среду здоровую? Спасибо.
Спасибо, Андрей.
Thank you. So they can claim, they can make 2 cases, and then the court could put them together. Making a collective claim is possible, but it's kind of hard to make a collective claim. And you also have to consider that the court is going to deal with 2 legal systems, the Russian one and the Finnish one. And there is no way of dealing with 2 systems simultaneously, because one of the group is covered by the Finnish legislation and one is covered by the Russian legislation. So a collective claim is difficult on the European Convention. If it's possible, I would say you should make 2 cases and then argue for them to be handled simultaneously. That would be a better approach, because you have to consider that Finland and Russia, they have signed different treaties, and Finland is part of the European Union, which Russia is not. So it's complicated, I can say.
Спасибо. Еще вот один вопрос. Я думаю, это ко всем нашим спикерам. В России, чтобы обратиться в Европейский суд по правам человека, необходимо пройти все российские суды. Какая ситуация в других странах? Необходимо ли проходить перед тем, как подавать там Межамериканский суд по правам человека, проходить национальные суды?
In the OAS system, there is a requirement by the Commission that you exhaust domestic remedies. However, this is somewhat flexible if you're able to explain why you were unable to exhaust those. So for instance, the judicial process is extremely slow, the state is not listening to the court system, there are not appropriate recognitions of the rights that you're alleging. So while you are required to exhaust it, you are able to make an argument as to why that is a challenge if you cannot properly bring a claim in your state.
I can just add to that, say it's the same under the European Court. You can make the claim that you can't go to the national court system, but the court is really reluctant to do that. And although Russia is on the bad side of the court, I should say that they should probably say that you should go to the court system first.
Спасибо. Вот здесь Любовь задала вопрос. Но я, Любовь, вы меня слышите? Если я не очень понимаю ваш вопрос, а может быть, вы его озвучите? Вот, что, каким критериям нужно соответствовать, чтобы подать иск от имени народа? Есть ли разница в подходах Европы и США и Америки?
Да, меня очень интересует. Добрый день всем.
Мгм.
Меня очень интересует, допустим, вот народ, допустим, ну, к примеру, какой-то индейский, да, народ подает суд, допустим, ну, против какого-то государства. У нас в России такой практики нет, насколько я знаю. И чтобы подать от имени народа, нужно, видимо, подавать от какой-то, может быть, некоммерческой организации. И вот все-таки вот практика, которая до, ну, скажем так, ну, в других странах какая есть, вот меня вот эта практика интересует. Допустим, как суды считают, ну, что именно, ну, вот эти заявители, которые подают в суд против государства, как они именно, ну, могут представлять целый народ. Потому что я думаю, что, ну, это серьезная проблема. И вот мне как раз интересно, вот все-таки, как это решается.
Спасибо, Любовь. Спикер, вопрос вам понятен, да? То есть, да, пожалуйста, кто готов ответить тогда? Мгм.
Yes, the question is clear, the answer is not clear. So if you want to file a case for people, you need someone who can represent all the people, and that is a challenge in itself, especially, I mean, take for example the Sami, they are one people, but really not, because there are different groups of Sami. So, I mean, who can represent all people? And is this just going to be a case that the court says, well, who are these members of the people? It's a challenge. For example, in Sweden, we have the Sami villages. They can represent all the village members without naming them, for example. That is one way. So if you have, for example, different villages that go together and form some organizations who has the right to represent all the village and all the members, then maybe it's possible. But you need someone who really can represent all the people.
Yes, I would agree that it's equally as complicated in the OAS system. And we've seen cases where two individuals have brought a case, like the Dan sisters in the United States. We've seen where several clans of an indigenous people have brought a case. And then we've seen where the entire collective and representatives of the entire indigenous peoples have brought the case. So there's been a lot of different examples, and it is equally as complicated in terms of who speaks for who and how those people's rights are adjudicated.
Спасибо. То есть, как я понимаю, практика будет, вот, те кейсы, которые уже были, разные, да, то есть там и несколько человек, или целая группа, или, наверное, какие-то организации подавали. Это так, да?
I would say that it would be hard for an individual to speak for a whole collective. You can have an organization who can speak for a collective if it has the mandate to do so, but then the mandate would be clear. It have to be clear.
Спасибо. Так, пожалуйста, Никита Каплин. Пожалуйста, вам слово. Ваш вопрос.
Меня слышно? Добрый день всем. Большое спасибо за возможность принять участие в нашем мероприятии. У меня немножко к вопросу Любовь задала вопрос, хотел бы комментарий. Необходимо уточнить сразу о том, что если вопрос задается тема по нарушению прав непосредственно народа, то тут нужно конкретно сразу определить предмет иска. Соответственно, необходимо будет тогда и круг граждан, которые пострадали или чьи права нарушены. Это в качестве комментария к вопросу, который задала Любовь. У меня следующий вопрос к Яну и Кристине. А какие существуют организации, которые могут в настоящее время, которые могут помочь общинам коренных народов или представителям коренных народов обратиться в суд по правам человека ЕСПЧ, чтобы квалифицированно сделать эту работу? Спасибо.
Пожалуйста.
Okay, so I don't have any organizations in mind now, but there are several in Europe, I would say. There are some in London, which are quite good. I could provide you with specifics later. What you need to consider when you have a case is that you need to start arguing the European Convention on the national level. On the first level, you need to incorporate it in your argument and listing which articles in the convention you would like the court to look at. Otherwise, you can't come to the European Convention level. But I can give you specific names later. I don't have any specific in mind now.
Спасибо, Никита. Я предлагаю вам, может быть, мы после нашего вебинара в ближайшее время, там, сегодня или когда-то свяжемся, и я готов тоже вам дать некоторые советы по вашему вопросу. Спасибо. Сейчас Вячеслав Шадрин.
Так. Ну, я хотел сказать вот о чем, да, вот, ну, вопрос. У нас большинство последнее время нарушений прав коренных народов увязывается вокруг понятия территорий традиционного проживания, территорий исконного проживания. Очень много таких вот моментов возникло. Дело в том, что буквально 4 года тому назад у нас в России произошла унификация всей вот юридической терминологии и оставили фактически в действующих законах оставили только терминологию, касающуюся территории традиционного проживания и традиционной хозяйственной деятельности, которая ограничена определенным перечнем мест. Вот. В то же время, как, например, там, в том же самом законе о гарантиях прав коренных и так далее, применяется термин об исконной среде обитания или об исторической и так далее, но они фактически сейчас не применяются. И вот, к примеру, последние правила того же самого рыболовства и много, они касаются только, что коренные народы могут осуществлять свои права только вот в этих вот территориях, которые определены этим перечнем. Но мы знаем, что в этот перечень очень многие места, территории и так далее в силу разных причин не включены. Вот это вот возможно ли, какое может быть решение правовое вот для этого, если, например, скажем, органы государственного управления и так далее не идут на изменение данного перечня? Какие пути возможны решения вот этого ситуации? Вопрос понятен?
Да, Вячеслав, вопрос очень понятен. Единственное, я думаю, что он очень специфический с точки зрения вот,
России,
именно России. Да. Здесь может быть очень сложно понимать Кристине, Яну, Кейт, так как это очень российская специфика. Я бы, если есть у Кристины или Яна, Кейт какие-то вот рекомендации или ответ, я готов, ну, вы можете ответить. Я бы просто сказал...
Самое интересное, вот, Павел,
Угу.
Павел, я бы хотел просто здесь небольшой комментарий, вплоть до того, что сейчас даже некоторые права, даже с идентичности, самоидентификации и так далее, пытаются привязать к этим местностям. Хотя по Конституции же мы, каждый волен сам волеизъявление своей национальности определять. Но сейчас вот очень много в том числе начинает определять, в том числе привязывая к местам так называемого традиционного проживания, традиционной хозяйственной деятельности. Вот вплоть до этого дошло. есть через какое-то определенное время нам могут просто сказать, если вы не проживаете, то есть если вы проживаете вне этих территорий, то вы, извините, не можете вообще относиться или относить себя к коренным народам. Вот такая ситуация складывается.
Да, спасибо, Вячеслав. Я единственное только хотел бы добавить, перед тем, как дать слово нашим спикерам, хотел бы сказать, что, Вячеслав, мы планируем провести еще один вебинар, который будет посвящен уже чисто российской специфике и с российскими юристами, экспертами, которые занимаются конституционными вопросами ЕСПЧ. Так что я думаю, что вот ваш вопрос, наверное, будет, мы постараемся ответить на него на том вебинаре. Сейчас в любом случае, может быть, какие-то есть рекомендации или вот ответы у наших спикеров. Микаэл, если вопрос понятен.
I can provide a little bit of context into how this is handled in the OAS system. The Court and Commission have made a distinction in tribal peoples and indigenous peoples. And so tribal peoples are essentially have the same characteristics of indigenous peoples, but are no longer on the territories where they have ancestral lands. So they're still viewed as a collective, but they're not tying that relationship to the land that they currently inhabit. And I'll also note that, you know, the connection between culture and land rights is something too that we've seen throughout the precedent in the OAS system, and has only recently sort of been extricated from each other as we've developed more indigenous specific language through the American Declaration.
Yes, I don't know if I have so much to add because it's really a specific question when you change the national legislation. But that is a problem also in Sweden where you have rights linked to land, but it only applies for a minority of the Sami population, which is covered by the legislation. And I think this is a general problem, which is not hard. It's hard to provide you with an answer how to deal with it. I mean, if you are not connected with your land, if you live hundreds of miles away, should you then retain your rights to that land or not? I mean, it's a difficult question. But I would like to hear the specifics because I really like when they change the law and they try to insert new words, which totally change it. But yeah, it was just a comment.
Спасибо. Олеся Балатаева, вам слово. Ваш вопрос. Олеся, вы слышите? Олеся, мы вас слушаем. Вас не слышно. Пока проблема с связью с Олесей. Геннадий Чукин, пожалуйста, Гена, вам слово, вопрос. Можете задать.
Я вот понял, что материальное право защищается ЕСПЧ, а вот вопрос нематериального права. Она защищается ЕСПЧ, традиции, обычаи.
Спасибо, Геннадий. Так. Наверное.
Yes, there are a lot of non-material rights covered. You have the right to your language. You have the right to be educated in your own language. You have the right to religious freedom, to protection of conscience and thoughts. So yes, the European Convention covers a lot of rights. As I mentioned initially, you could make argument based on other articles as well. I just focused on the property rights articles. For example, in Canada, I know that they make land claims arguments based on viewing the land in a certain way as a living creature or containing more religious aspects. But yes, you have a lot of rights, other rights covered.
Спасибо. Сейчас еще Никита опять хотел Капни задать вопрос. Пожалуйста, Никита.
Спасибо, Павел. У меня вопрос к Кэт, Кристине и к Яну. При подаче иска в суд Межамериканский и в суд по правам человека в ЕСПЧ, какой документ должен предоставить заявитель, который будет подтверждать его национальность, то бишь принадлежность к коренным народам? Или вот у меня следующий вопрос. Или это свидетельство о рождении, как в Российской Федерации, где указана национальность отца и матери, или другой документ, который выдается общественной организацией или общиной коренных народов? Спасибо.
Спасибо, Никит. Пожалуйста.
I can give you a short answer. I have no idea. I don't know exactly, but there are cases where the court made their own judgments based on the documents that you submit. Because, I mean, usually if you submit something from that is officially from Russia, they would recognize it without questioning. If it comes from an organization, they will probably, it depends on the organization, but you could submit any document claiming that to prove your belonging. But you will always remember there will be another person on another side saying that this document is not valid at all. But yeah, you could basically submit anything, whether it's of value, it's up to the court.
Yes, in the OAS system, you're simply self-certifying or self-identifying as Indigenous. And so you don't necessarily have to submit anything unless you want to submit something potentially, explaining why you're speaking on behalf of a people's. For in the United States, that could be a tribal resolution passed by the tribal government, but that's not required. It would simply be part of your supplemental documentation.
Спасибо, спасибо большое. И вот здесь как раз есть сообщение, наверное, это Никита, к вам, к вашему вопросу тоже относится, и, может быть, для других будет интересно. Написано, что вы можете в Российской Федерации по поводу ЕСПЧ, обращения в ЕСПЧ, обратиться в Институт права и публичной политики. У нас эти контакты есть, так что если у кого-то нет, мы вам обращайтесь, мы вам пришлем контакты. Я вот, может быть, еще здесь Виолетта написала. Виолетта, если вы можете написать свой контакт прямо здесь, было бы здорово тогда. Например, куда можно было написать, по какому адресу. Спасибо. И здесь еще вопрос, как долго рассматриваются дела. Вот мы уже слышали там, да, по Межамериканскому суду по правам человека. Может быть и 2 года, и годами длится. А по ЕСПЧ есть ли какой-то анализ, как долго длятся дела?
I would say, well, it takes a couple of years. It depends on the case and the issue. It also depends on how many levels it will go through. Some cases could go through the Grand Chamber, and that takes a long time. But I mean, it takes a couple of years, and of course, first you have to go through the national court system. So it will be a process of 7-10 years, something like that.
Спасибо, спасибо. Ну, вот здесь вот еще Любовь написала В России действует практика, по которой обжаловать запреты в правилах рыболовства может только самому пострадавшему человек. Далее он должен пройти все суды в России. А может ли народ подать в Европейский суд по правам человека на запрет в правилах рыболовства, который не дает возможность заниматься рыболовством на протяжении длительного времени и на огромной территории коренных народов?
So there are two questions there. The first question is how were the rights deprived? How long have they been deprived? That question relates to whether you are arguing for that you should have the rights, constitution, you should have the rights again. For example, you have the rights, you lost them, and then 5 years after you want to have them again. Then it's, I would say that the rate of success is very low. As for the other question, if a whole nation can claim fishing rights, it goes back to the question who can represent the whole nation and who are the nation. It's the European Court is not a place where states can take states, for example. They did that in the beginning, but then the states went there for individuals. So it goes back to the question, who is representing this group, which it should be not a state, but the group and who belongs to the group, and do you have the right to speak for the whole group? But I think the primary question is, when were the rights lost? How were they lost? Because if they have been lost or legally extinct, you would have no success in the European Court. Thank you.
Спасибо большое. На самом деле, да, вопрос, который задала Любовь, он очень актуальный. Я думаю, что необходимо поработать с юристами для того, чтобы обсудить вопрос, потому что в реальности, конечно, это лишение многих народов права к доступу к традиционной еде, а вообще даже, можно говорить, и право доступа просто к еде. Потому что для многих рыба является, если не единственным, то очень важным источником питания. И если этого не будет происходить, то, конечно, в том числе может наступить и голод, и другие всякие проблемы, которые приносят эти запреты. Я думаю, что это важный вопрос, который необходимо было бы пообсуждать. И я хотел бы Кристины и Кейт задать, вот здесь Клаудия задала вопрос на английском в чате. Готовы ли вы?
Yes. So Claudia asked, the indigenous human rights are aggressively and actively being violated in Colombia. Which international organisms should be approached and which would be the best way to approach them? The situation in Colombia is devastating. Are you aware if Colombia is being addressed in any way? And how can we internationally help the Colombian indigenous peoples? So I'm aware of 2 cases right now that are very recently referred from the commission to the court. So one, I believe, is on a collective right to property over ancestral lands. And then I know another is about the situation of violence facing human rights offenders. So both of those are now in the hands of the court as of the fall last year. So as we've talked about, this will take a few years to go through that process. And whatever the court decides will then be binding on Colombia. Additionally, there are other ways to get attention and elevate those rights in the OAS system. You can engage with the special rapporteur on indigenous issues or other rapporteurs on issues related to what's happening in Colombia, and elevate that for perhaps a report, ask them to visit the country, and again, you can engage at the UN level as well through other mechanisms there. Similar, submit a request to the committee to eliminate racial discrimination if that's possibly relevant. There's a lot of different levers that you could potentially pull, but I do know that there are cases moving through the system on a few different issues going on in Colombia right now.
And I'll just put a finer point on what Christina had just said. I know that the situation in Colombia has recently gotten very dangerous. We know that there's a lot of violence occurring right now as we speak. I don't know right now what the exact strategy is, but I know that there's a number of different organizations that are working hard to figure out the best way to deal with the issues now. I think all of us are lawyers. We appreciate the court system, but it is slow. So there's a number of different mechanisms that are being leveraged right now in order to help the situation.
Спасибо большое. Я хотел бы еще российским участникам в чате опубликована как раз почта Института права и публичной политики, куда вы можете обращаться. Посмотрите, пожалуйста, есть контакт почты. Еще будут вопросы, у нас осталось 5 минут до завершения нашей встречи. Ну, вот здесь я не хотел бы, здесь есть вопрос от Тины Совкиной. Меня интересует вопрос, вот какое отличие: исконные земли и традиционные земли. Чем они отличаются? Здесь, я думаю, что, конечно, надо смотреть определения, которые даются по исконным землям, по традиционным землям, которые прописаны в законодательстве. Хотя, конечно, в российском законодательстве столько терминов ввели, что, да, очень достаточно сложно в них разбираться и так далее. Так, еще будут ли какие-то вопросы? Гена, пожалуйста, Гена, вам слово. Очень коротко.
Если, допустим, вступило в силу решение ЕСПЧ, то национальное государство должно поменять свое законодательство?
Well, if you have a ruling before in the European Court, the national government should make some changes according to the ruling. What it results in change of legislation, it depends on which way the government or the state want to go. It's up to the state to make the changes necessary to fix the ruling. That said, there are cases, a lot of them, where the state doesn't do anything, and then it goes to the Council of Europe. But it's not automatically a legal change in law if the court rules anything.
Спасибо большое. Последний вопрос, я думаю, Валентина Совкина. Валентина, вам слово.
Добрый день всем, спасибо за встречу. У меня вопрос вот такой. Мы проводили тоже семинар, выступал Сергей Автономов, может, кто-то, многие из вас знают его. И мы как раз поднимали вопрос о тех территориях, которые были изъяты в свое время в 60-е, 70-е годы. И у нас сегодня мы не можем на них заявиться как территория традиционного природопользования или просто территория проживания самок, потому что они отданы, там, например, военным, под военные базы там, или под промышленность. Вот. И тогда он упомянул вот именно слово «исконные территории», то есть чтобы нам заняться доказательством, что они исконно нам принадлежали. То есть вот меня вот этот вопрос почему-то, ну не почему, а интересует. И я поэтому задала вопрос, что термин «исконные территории», он выше, чем традиционные, и можно ли вообще что-то в этом направлении сделать? Наверное, большой очень вопрос.
Да, я думаю, что вопрос, конечно, да, Валентина, ваш очень большой. Я просто хотел бы, перед тем, как дать слово спикерам, хотел бы просто упомянуть, да, что в некоторых странах такой процесс идет. Например, я могу упомянуть в этом плане Австралию, когда австралийский Верховный суд принял решение о том, что когда-то, там, я сейчас точно не помню процент, но они признали чуть ли не 86, что ли, процентов территории, которые принадлежали австралийским аборигенам. Но в связи с тем, что в реальности ситуация сейчас по-другому сложилась, что эти территории были забраны у коренных народов, от австралийских аборигенов, в этом случае Верховный суд постановил выплатить компенсации за утерю земель правительству Австралии, коренным народам. И этот процесс переговорный, он идет, ну и так далее, он уже идет давно, но этот процесс есть в ряде стран, не только в Австралии, в других странах, поэтому, да, этот процесс, вот он есть. Я не знаю, может быть, вот у наших спикеров, может быть, другие примеры или и так далее. Вопрос, пожалуйста.
That's an interesting question. I don't remember when Russia became a member of the European Convention. If this happens before or after. If it happens before they became a member of the European Convention would not. They don't have the mandate to deal with it. There is a case from Greenland which basically covers the same thing. So America established an army base in Thule, and the indigenous peoples located there had to move, but they got compensated in some way, and the court basically didn't address that issue. They addressed whether they had been compensated or not adequately. So yeah, that's, I mean, it's an interesting question what happens if someone takes your land. Whether it would be an issue for the European Court, it depends on several issues. Thank you.
Так, спасибо большое. Если больше нет вопросов, и я хотел бы тогда завершать, у нас время подошло к завершению. Во-первых, я хотел бы еще раз сказать огромное спасибо Кейт, Кристине, Ян Микаэлю вам за очень интересные ваши презентации, рассказы, которые, я думаю, для нас очень важны и полезны, дает много пищи для размышлений, дает возможность подумать о том, как можно было бы применить те полученные знания, информацию для своей каждодневной практической работы по защите прав коренных народов, используя вот эти международные судебные механизмы. Я также хотел бы выразить признательность всем, кто принял участие, кто сегодня задавал вопросы. Я хотел бы сказать, что фонд Батани планирует провести ряд вебинаров, посвященных опыту различных стран, регионов мира по вопросам экономического развития общин коренных народов, о том, какие программы существуют у самих общин, чтобы этими программами информации поделились представители общин, как они разрабатываются, какие государственные программы существуют по этим вопросам. Еще одна тема, которую мы обязательно будем затрагивать, то, что сегодня об этом мы много говорили, это земельные и ресурсные права коренных народов, как они решаются, эти вопросы в других странах. Актуальная проблема для нынешних приобрела для России, для нашей страны, это принадлежность коренным народам или так называемое введение реестра коренных народов, которое недавно было принято в России. И мы тоже послушаем людей, представителей коренных народов, специалистов из других стран, как это делается в их странах, кто за это отвечает, и самое главное, зачем это делается. И я очень надеюсь, что это будет вам интересно, и вы будете присоединяться к нашим вебинарам. Итак, еще раз огромное спасибо, Кейт, Кристина, Ян Микаэл, вам за то, что вы сегодня уделили нам время, рассказали о той работе, которую вы проводите, о тех историях, которые очень важны и актуальны для коренных народов. Я также хотел выразить признательность сообществу помощи угнетенным народам из Швейцарии, которые помогли нам и помогают в организации вебинара. И, конечно же, First People Worldwide за то, что вы нам помогли организовать первый наш вебинар. Спасибо большое. Я единственное хотел бы попросить наших спикеров остаться еще, может быть, минут на 5. Мы еще бы отдельно с вами поговорили. Спасибо большое всем участникам. До новой встречи. И, конечно же, огромное спасибо нашим переводчикам, Любе и Марии, которые помогли нам сегодня провести такой интересный и очень важный диалог, такую встречу. Спасибо вам большое. Так. Угу. Да, если можно было, да. Спасибо большое. Так, ну, вроде бы, да, все вот у нас вышли, наши участники. Да, спасибо большое. К нам сейчас присоединилась Дженнифер. Дженнифер, вы меня слышите? Все. Дженнифер, спасибо вам большое за то, что вы нам предоставили возможность, да, за то, что помогли нам провести этот вебинар. Большое. Угу. Да, вы, может быть, скажете несколько слов? Да, я хотел бы тоже, да, познакомить, чтобы вы, я не знаю, Кейт, вы знаете Дженнифер? Дженнифер, вы знаете Кейт?
No, I don't believe we've met. And I was really pleased to be able to offer the opportunity to host this webinar. I apologize for being late to join it, but Kesha Grekov was also a big help in getting us started with it. And I look forward to hopefully hosting webinars in the future for Batani and as needed. So thank you all so much for your presentations and great discussion.
Да, спасибо большое. Я просто хотел бы, может быть, Дженнифер, если не возражаете, представить вас, да, что Дженнифер возглавляет организацию Altai Project. Это организация, которая работает с коренными народами России по вопросам экологии. Дженнифер, мы знаем, знакомы тоже уже очень-очень давно. Дженнифер является членом попечительского совета фонда Батани, помогает очень много в нашей работе. Спасибо, Дженнифер. Да. Ну, вот наших спикеров вы видели, там их, да, и вот с Кейт мы тоже знакомы уже очень давно. Кейт очень много, мы работаем с ней. Кейт нам помогает по разным тоже вопросам. Вот сейчас с Кристиной познакомились. Ну, вот с Яном Микаэлом мне прислали, вот, Ян Микаэл, вашу работу как раз по возможностям ЕСПЧ для защиты прав коренных народов. Я с ней ознакомился, и после этого мы обратились к вам. Таким образом, я тоже очень рад знакомству с вами. Спасибо еще раз огромное вам за то, сегодня вы с нами провели этот вебинар. Еще раз большое спасибо, Кейт, вам огромное, Кристина, за очень интересную информацию, рассказ. И если вы не возражаете, я буду вас теребить иногда, просить вас присоединяться к нам по другим вебинарам, потому что на сегодня один из важнейших вопросов, который очень актуальны в России. В России был недавно принят закон, точнее, он не отдельный закон, а внесли изменения в законодательство о так называемом реестре коренных народов. Этот реестр, куда записываются представители коренных народов для того, чтобы как бы воспользоваться правами. Хотя на самом деле этот реестр, по нашему мнению, он антиконституционен, он, наоборот, нарушает права коренных народов, потому что он ведет к разделению народа. То есть это первое. Второе, что этот реестр ведет Федеральное агентство по делам национальностей. Это министерство, ведомство федеральное. При этом его ведет отдел, который занимается мониторингом экстремизма, сепаратизма, терроризма и так далее. То есть, там сидят сотрудники ФСБ, да, которые все это дело обслеживают. Нас как бы чуть ли не приравняли, да, для того, чтобы... и фактически там очень много данных, коренные народы должны давать, и непонятно, куда эти данные, ну, понятно, что уходит в это федеральное агентство, но дальше непонятно, что с ним происходит. Да? То есть фактически федеральное агентство, которое занимается, да, вот, вопросами безопасности, в том числе, получает все данные о человеке, да, о представителях коренных народов. На самом деле дальше идея для меня абсолютно понятна, зачем они это делают. Они хотят разделить народ на тех, кто ведет традиционный образ жизни, да, кто занимается охотой, рыболовством, оленеводством, и те, кто не ведет, кто не занимается. И как бы и хотят разделить. Вот эти вот будут получать, эти не будут получать, ну и так далее. На самом деле уже это происходит. Ну, в общем,
Я
это
прошу
много
прощения за то, что я перебиваю. У нас до сих пор идет запись, которую мы собирались опубликовывать. Ее остановить?
Я думаю, что если что, мы можем потом обрезать, да, Женщина, можно это или